joiner to do so in the Christian way. Thank you.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين إن الذين قالوا ربنا الله ثم استقاموا تتنزل عليهم الملائكة أن لا تخافوا ولا تحزنوا وأبشروا بالجنة التي كنتم توعدون نحن أولياءكم في الحياة الدنيا وفي الآخرة ولكم فيها ما تشتهي أنفسكم ولكم فيها ما تدعون نزلا من غفور رحيم ومن أحسن قولا من دعا إلى الله وعمل صالحا وقال إنني من المسلمين سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين آمين.
In the name of the Father, the Son, and the Holy Spirit. Amen. Dear Lord, everywhere I walk, let it be on your path. Everything I see, let it be through your eyes. Everything I do, let it be your will. For every hardship I face, let me place it in your hands. Every emotion I feel, let it be your spirit moving in me. Everything I seek, let me find in your love. My dear God, I thank you for this day. I will not ask where I am going, but only to know and feel in the depths of my heart and soul that you are with me. You are guiding me, and I am safe. This I ask through Jesus Christ our Lord. Amen.
Thank you so much. Registrar, can you please call the witness?
Good morning, witnesses. Please sit down. Before I yield the floor back to Madam Chair for continuation of proceedings, may I remind both of you that you are still under oath. Madam Chair, the floor is yours.
Good morning, Mr. Jete, and good morning, Mr. Tamura. Welcome back. I will now hand you over to the council for us to continue the proceedings. Thank you.
Good morning, Mr. Jete. Mr. Tamura, it is good to have you again. Madam Chairperson, with your permission, we will want to proceed with the 2019 compliance review report, which we were dealing with yesterday. And then we have some exhibits we want to tender through these witnesses. So I had referred you to page 18 and 19 of the 2019 compliance review. Can you please advise me whether you are currently on that page?
Sorry, I'm just checking.
Are you there now? Yes, for BCC. Can we proceed?
Yes.
Very well. So page 18, that overlapped to page 19, we have discussed the table that has been contained in your report regarding procurement conducted using single source without prior approval from the authority. Do you recall?
Yes.
And so we discussed about 21 procurement conducted, in fact, without obtaining prior approval. The minimum amount probably that was procured was the amount of $26,000, and the maximum was about $382,500.
Yes.
That is with respect to the structuring of the BCC, and the supplier was UXL Group. Do you follow?
Yes.
Yes. So we discussed the findings of your review. The first point we discussed was that you've observed that there was no justification for the use of single source method for the above procurement. And in addition, you highlighted that there was no prior approval sought for above mentioned single source procurement. That was the first point you highlighted.
Yes.
Now, the second point, can you take us through the second point, wherein you have observed that you said in addition to the use of single source above the threshold, Council had conducted procurement, has also used RFQ, request for quotation, for certain procurements above the threshold without prior approval. Can you please discuss that point with us, please?
Thank you, Council. The prior approval, as I stated yesterday, they are needed for the conduct of procurements whose values are above the, in this particular instance, above the single source threshold. Looking at the amount involved, the law requires that BCC was supposed to submit this particular request to the authority for prior approval at every stage of the procurement proceedings. In this particular instance, BCC failed to do so.
And this was in relation to which project?
It was in relation to the renovation of the Crab Island public toilet.
Very well. I think you have mentioned in detail subsequently the project that we will discuss after we have exhausted this point. But
Yes.
now the third point is that the procurement was conducted by individuals outside the procurement unit. That the contract was awarded to Bassen Enterprise at bid price of $662,106. Do you see that?
Yes, sir.
Yes. Please tell the commissioners what this finding was.
Because the law requires that the specialized procurement unit, that's the SPU, it is the only unit within institutions, including councils, that is mandated for the conduct of procurement. In this particular instance, those who were in charge, or those who really conducted this particular procurement, were members outside the specialized procurement unit, which constitute a violation of the Act.
So in essence, how do you summarize the non-compliance that occurred with, in BCC in relation to these transactions?
Specifically, is disobedience to statutory provisions, and it's a violation of the Public Procurement Act 2018, basically.
What is the risk attached in relation to exposing these public funds to fraudulent activities or misappropriation when there are serious violations of the laid down regulations?
Fundamentally, holistically, there is once there is a compromise in the process, the fact that those involved are not members of the SPU, here the risk includes whether the processes were followed or not, but fundamentally, value for money, was it achieved or not? So if value for money is not achieved in a particular process, that has a trickle-down impact.
In fact, in the implication column on page 20, two of the main points you've highlighted which could be probably an implication for the non-compliance,
Aspect, yeah.
is that there will be no transparency of the procurement process, number one, and then there's a potential conflict of interest. Do you see that? What do you mean when you say that there will be no transparency, or transparency may be compromised, or there is the potential of conflict of interest in the process?
Here, the first question we should ask is, why is it that those mandated to conduct the procurement did not conduct the procurement? Why? That's a rhetorical question. Potentially, there may have been some vested interest. That's why they conducted the procurement. Because if there is a bona fide person appointed to conduct a particular role, to function in a particular manner, the person is not given the opportunity to do so, somebody outside is given the opportunity. These things are red flags in procurement. About the transparency, because the procurement officer is mandated to administer GPPA forms, and those GPPA forms, they are designed in such a way it brings about transparency, because you have the requisition, you have the other forms 101. All those forms goes to promote transparency. Therefore, it means the fact that the right person has not conducted the procurement, these other forms were not completed, were not administered. So there is a compromise in the transparency bit.
Now, on page 21, we have the issue of record keeping of the procurement activities. What can you tell us about your findings and the non-compliance in relation to record keeping with respect to procurement activities?
In this particular instance, BCC did not file their procurement transactions as provided for in the regulation. One, most of the supporting documents were not also part of their procurement transaction. This includes, but not limited to, GPPA requisite forms, receipts sometimes not attached in certain transactions, delivery notes sometimes not attached in certain transactions. All these things goes to support a procurement process, which we are grossly inadequate in this particular instance.
Please turn to page 23 of the report.
23.
Yes. The heading is pre-qualification and registration of suppliers.
Yes.
What is pre-qualification and registration? Is there a requirement for a pre-qualification and registration of suppliers?
Yes. Depending on the procurement method you intend to undertake, most of the time, pre-qualification, for instance, if you want to go in for restricted tender, that's pre-qualification without publication. We have two types generally, pre-qualification without publication and pre-qualification with publication. For restricted tender, depending on what you want to buy, if you have a list that's internally, if you have a list of suppliers that you have already pre-qualified, because there are potential suppliers that are already known to you, let's say vehicles. Each institution can pre-qualify all the vehicle dealers in the country. Once you want to go in for vehicles, you just go to the list and select, because they are limited and they are already known for you. On the issue of registration, the law requires that before you deal with any procurement economic operator, they must be registered with the authority. So basically, these are the two precise explanations.
So now, in this process, there were non-compliance issues.
Yes.
And what were these issues? In what areas did they not comply with?
Especially on the issue of registration.
Yes.
Yes. It was observed that some of the suppliers they awarded the contracts were not registered, and BCC did not have a list of pre-qualified suppliers in their database.
So contracts were awarded to suppliers that were not registered with GPPA?
Yes, some contracts were awarded to suppliers who were not registered.
How detrimental is that?
One, of course, is a violation of the Act. Remember,
Yes.
the Act is promulgated for a purpose. We don't expect anything to be done that constitutes a violation. The Act requires that suppliers must register before you deal with them. That's one aspect. Secondly, we are trying to do away with the issue of suitcase vendors. which is very common, which is a menace now. Dealing with contractors, suppliers, giving them public funds, etc. When you don't even know whether they are serious, they are established, they have registered offices. When you are registering with GPPA, these are the things that we looked at. Are you registered with the AG chambers? Are you registered with GRA? Pay your taxes before finally we register you. So it means any supplier that is registered with GPPA has fulfilled the other preconditions. AG chambers, register of companies, GRA, before you are finally registered. So it means in the event of whatever happened, you can easily be traced. It's a tracking system. And in the registration, your area of specialization is also captured. He's registered for this specialization, this is his specialization, etc., etc.
In fact, that was supposed to be my next question in relation to what is the importance of registration, basically, which you have clearly highlighted. Okay. If there is a requirement that suppliers or companies that wants to take part in bidding processes or procurement activities in our public offices must be registered with GPPA, there must be a reason for that.
Exactly.
You've highlighted some of the reasons. One of the reasons is that they can easily be traceable.
Yes, exactly.
So they can be monitored as well.
Exactly.
And then you can now deal with a company, probably that is an expert or specifically focusing on one area.
Yeah, exactly.
Do they pay? Are there any registration fees that are paid?
At GPPA level?
Yes.
Yes, sir.
And then, of course, to also register your company as well, you have to pay at the AGS chambers, which you have highlighted, that you must register with the AGS chambers.
Exactly so.
So, if a supplier did not follow this process, does that cause losses to government? Because your GPPA is government.
Yes, it's losses to government. If you don't follow the process, my understanding is from AG chambers to GPPA, that's a process. Of course, it's losses to government. Maybe the amount accrued may not be the fundamental issue here, but of course it's losses to government because you pay something, and what you pay is public funds, of course.
In fact, it is very fundamental. The amount, no matter how meager it is, I don't want to even know how much it is.
It's still public
very
funds.
Fundamental to the economy of the country.
So,
that I can tell you for a fact. Now, so in BCC, they deal with suppliers that we conclude that do not register with GPPA.
Yes, some of the suppliers. Yes.
Some of the suppliers.
Yes.
Now, on page 24, we have the heading specifications.
Sorry,
Yes.
Council. Mr. Tamura, can you provide us with schedule of fees from your office that businesses, what categories, what payments do they make to your office?
Yes, that is available and it can be provided.
Thank you.
Thank you, Madam Chair. May I proceed?
Yes, please.
Yes, so page 24, are you there?
24, yes.
There and you have discussed the issue of specifications.
Okay.
What is technical specification in procurement?
Generally, these are the technical requirements. They go to determine the fit for purpose bid and the quality bid of any procurement product. So, in other words, it tells any supplier or any institution exactly what you are looking for. It determines, it defines whatever you are looking for, whether works or goods or whatever. So basically, these are the technical specifications.
And
yeah.
So it is a fundamental requirement, is it? In any procurement process?
Very fundamental.
And again, there were non-compliance issues.
Especially in the area of request for quotations.
Yes.
Yeah, because most of their procurement, what we realized was they did not define their specifications. And failure to define your specification begs the question, what actually are you looking at? Because if you said you want a vehicle, how can people compete for the supply of vehicle? Because that is very vague. You have to tell us what type of vehicle do you need, the specification, you have to direct us. So in the absence of that, it makes the whole show messy.
And so the implications, according to you, would be value for money may not be attained?
It can be compromised.
quality could be compromised due to the absence of specification, which we have already discussed.
Certainly.
And the third is award decisions is likely to be discretionary
Yeah.
instead of responsiveness. What do
Yeah.
you mean by that?
It simply means it may be biased. Because let's say this example I've just given here, that analogy, I need vehicle, please supply me with vehicles. Or you say, okay, I need mobile, supply me with mobiles. Maybe my intention was one SIM mobile, something like that. If 3 people submit mobiles, you disqualify the 2 because they provided you double SIM mobile, and you award the one that supplied you the one SIM mobile. What is the basis of your award decision? Because you never said one SIM mobile, you just said mobile. So that's why the award decision would be discretionary and most of the time biased.
So if there were very clear specifications, all the bidders probably, there will be fair competition and they would know what the requirements were, what the insured is looking for.
Yes, actually what it does is a level
Playing field.
Yeah.
So if I now, as a procurement officer or a procurement authority, want an individual that I know who sells a single SIM mobile phone, and I want to award that person the contract, I can just decide to not put any specification, and the other bidders may run the risk of not meeting the specification, while the person I am dealing with or intend to deal with meets the specifications. Is that what you're saying?
Yes, and by extension, it also violates another fundamental principle of procurement, that's equal treatment.
Yes.
Understand? Because if your decisions are discretionary, it is a problem. And equal treatment, very wide, but it also means you have to communicate to the suppliers, to the economic operators. You have to give them the same information so that they can compete on a level playing field.
Yes. So now, please turn to page 27.
27.
With relation to the formation of contracts.
27.
Yes. So, are you there with me? It is in relation to formation of contracts, where you found out in your review that contracts were being signed by
Yes.
council, and then they don't send these contracts to the authority for approval. Yes, in addition to other findings as well.
Yes, that's right.
Yes. So, what is there a need? Is there a requirement for contracts that are signed by these institutions to be sent to your authority for approval?
From the provision of the Act, it stipulates that at every stage of the procurement process, and the understanding as per the report here is that contracts formation are an activity in the procurement process. So we always urge institutions to submit especially draft contracts before they are finally signed, so that if there are issues of inconsistency, because here once these contracts, especially draft contracts, are submitted, we try to benchmark, we try to compare between the draft contract and the initially submitted bidding document requirements, because the contract document has to be consistent with what is in the bidding document that you initially submitted, because you cannot change the game in the middle of you cannot change the rules in the middle of the game. So in this case also they fail in certain circumstances.
So they fail to in some or most cases to submit them for approval, number one.
Yeah.
And in fact, not only that, but there were other non-compliance issues as well, when you have highlighted that they don't even send those reports monthly or annually to GPA on contract transactions conducted using single source and request for quotation, annual single source procurement, and procurement plan as dictated by law.
Yes, these are monthly returns that are expected to be submitted on a monthly basis, but in this case they also fail to honor this obligation.
what is the reason or the purpose for sending monthly or annual returns? Is it for supervisory requirements so that you will know what is happening in these institutions?
For two fundamental reasons. One, remember, we always go for post-review at the end of the year after the whole transactions are done. If these monthly reports are submitted to us on a monthly basis, it means we are able to know the activities they have been doing over the period, over the month. And we collate all these things, get the statistic. When we go for our post-review, you'll be able to compare. What you submitted before, is this the exact thing we found on the ground? That's one reason. The other reason is for real-time detection of possible violations. Because if these things are submitted, the forms are designed in such a way, if they are submitted, if there are some violations, we always see the red flags. So we'll alert you. You have submitted A, B, and C on this particular month, but there are issues, please check. So just to help to detect real-time.
In fact, that seems to be very important because from your explanation, here we have a problem of non-compliance with basic requirements, basic procurement requirements, wherein individuals, I dare to say, will conduct procurement activities and then without following due process. And now, in addition to that, they still fail to comply with the monthly or yearly returns. So that probably would kind of hinder the work of GPPA in detecting these problems either at an earlier time or in fact for a long period of time.
Yeah, so because the detection may be at a later date.
Now, we had discussed on page 18 and 19 with respect to the procurements that have been conducted without prior approval.
Yes.
We have seen the numbers. Now, in chapter 3, page 31, you have gone through specific findings. Some of these findings were being captured in one way or the other in the table we have discussed on page 18 and 19. Now, can we discuss some of these findings one at a time?
Okay.
The first finding was procurement of staff ID cards. The category is goods. The amount is $87,500. The awarded contractor is Global Alliance USA Gambia Limited. The procurement method is single sourcing. Now, there were non-compliance issues with that. Please tell us about the non-compliance with respect to these transactions.
Yes, fundamentally, just to sum the non-compliance, the procedures were not followed as per laid down law and principle. The threshold is above the threshold for single source. The requisite forms were not administered. There were no evaluation reports. So fundamentally, the critical aspects of procurement, especially in terms of supporting documents, we are really missing in this particular.
And the procurement was also conducted or done by people outside the procurement unit.
Procurement unit,
Do you know by who, by which individuals?
We did not actually mention here, but in our raw data at the office, we should be able to establish exactly.
Can we have the names? When can we have, if you come back tomorrow, is there any way that you can tell us the names of the individuals that conducted these specific procurement activities without being members of the SPU?
Yeah. Okay, I'll endeavor to dig into our files to record, just to confirm where actually
Yes.
the names were actually captured.
Yes.
Yeah, I'll endeavor, and whatever the case may be, you'll be updated inshallah tomorrow.
The same occurred on page 32, where you have a procurement of a Dell computers.
Yes.
Now the category is goods. The amount is $58,000. The awarded contractor Mar Banta Suppliers. The procurement method is RFQ, request for quotation. What were the main non-compliance issues or findings?
Yeah, very similar. Most of the specific findings, are issues that we thought there is a need to make some highlights. But naturally, as I told you yesterday, one of the committees that is needed at institutional level is the Receipt and Examination Committee. So if you don't have a Receipt and Examination Committee and you go into procurement, so the delivery there could be a mismatch between requirements and actual delivery. Evaluations were also absent. The forms, administration of forms were also absent. So, as I said yesterday, if these things are absent, it means a lot of things are compromised. Because these forms, for example, Form 101, that's where you define your requirements.
In fact, the other issue is no evidence of delivery notes for the said procurement as required.
Yeah.
What is a delivery note?
Basically, a delivery note is a document of proof that a particular product has been delivered to the rightful recipient.
And that was not present in this situation.
Yeah, we could not have any trace of that.
So you have a procurement, conducted at the tune of $58,000.
Yes.
But there was no evidence that, in fact, the good was in fact being purchased.
Exactly.
And the issue of branding, I see it across most of the procurement reviews.
Yes.
That it appears as if there is a prohibition, or perhaps the act discourages branding, trying to draw out specifications with respect to a specific brand.
Yes.
Please educate us on that.
Branding, it depends on the jurisdiction. As for globally it is not accepted. Globally, that's the best practice. But coming back to our country system,
Let's talk about the practice itself first before
Yeah,
we
yeah.
go. What is the prohibition against branding?
yes, it is prohibited.
What is prohibited? When we say branding, it's just it does not by itself explain
Okay,
what it means. So when we say there's a prohibition against branding, what are we talking about?
here is a specific reference to a particular brand of an item.
For example,
In a brand of vehicle, let's say if you say Toyota, that is a brand. So if you say now, we want the supply of Toyotas, that's okay, you have mentioned a brand. So what does it mean? It means automatically, any supplier in the country that does not deals with Toyota is automatically excluded from the competition. And that's the fundamental issue, in fact, because branding goes to a very large extent to discourage competition, because it is only those that specialize in that particular brand can participate.
Okay, before you, so if we could understand it much better, is that why sometimes it is required for you to use restricted, tender?
The restricted tender, not because of branding, no, that is not a condition for the use of restricted tender.
Thank you.
Yeah, in fact, we discourage the use of branding.
Okay.
So branding here, just to understand you, is that the whole idea of procurement in public in a public institution is to create a fair competition. Number one,
Yes.
get value for money, get probably the best product, and based on the specifications and in addition to other requirements. But then if you now put highlight a particular brand that you want, let's say Toyota, for example, you may exclude other competitors.
So,
And then, in effect as well, not only are you excluding other competitors, you may also be targeting a specific supplier.
so.
Sure, as in,
That's what I'm saying. It means you are targeting only those that are dealing in that particular brand.
would there be a room for let's say bias in these situations?
That is already biased. The fact that you have automatically disqualified any other potential bidder from participating, and you want to concentrate on probably one bidder or one supplier, that in itself is not a level ground. For
There were
competition.
also no minutes of the contracts committee meeting in this situation as well. So, is that to say that there was no evidence of approval of the authority, internal authority?
This was an internal thing that was done at BCC level, but the law requires that. Yesterday, I think I made mentions of it,
Yes,
that you cannot handle procurement alone.
yes.
There is a contracts committee that oversees all procurement. So therefore, in the event of any procurement activity, the expectation is the contracts committee has to come, sit and agree on a course of action. It's very possible if the contract committee had sat over this thing, discussed, maybe a different line of action could have been taken.
Yes.
Different from maybe single source or RFQ and the like. So, but that was really absent at all. So, probably it was handled by an individual.
Again, in the, on the issue of no evidence of delivery notes or receipts, we had the same problem
Before, yeah.
before on page 31 with respect to the procurement of staff ID cards amounting to $87,500.
Right.
Yes. So now on the same page 32, there were procurement of metal windows and truss gate. Do you see that?
Yes.
The category is goods. The amount is $111,700. The awarded contractors or contractor, Dembas Trading, and procurement method was RFQ, request for quotation. There were issues of non-compliance with respect to this particular method of procurement.
Yes.
Please take us through the non-compliance issues.
Yeah. I think if you look at the trend, the non-compliance aspect of these specific findings are very
Similar.
similar.
Yes.
So a general statement would help the commission to understand that all the specific issues here, most of them, almost all of them, they lack the requisite supporting documents. These supporting documents tells us whether the process was really followed to the latter, whether there were no compromises in the basic principles of the procurement. So generally, the findings were very consistent throughout.
Yes, they are. In fact, but then the findings, in fact, or non-compliance, sometimes one is much more serious than the other.
So,
For example, when you purchase or when you conduct a procurement, or like when you conduct procurement, an activity using public funds, and there is no evidence that what you said you paid for is in fact being paid for or being purchased. That's in fact the same is being repeated in this situation.
exactly.
Wherein you have an amount of $111,700 being subject of a procurement activity, and there is no evidence that the goods were being delivered. That is also a problem you've highlighted here.
Yes, it's
And-
present here, and also, if you check, there were no evaluation reports also, because these things are very important.
And there were no also minutes of contract
Contracts committee.
meetings.
Yeah, that's why I said it's a repeated trend.
Yes.
It's a repeated trend.
The other one on the same page is the procurement of air tickets.
Yes.
$276,768 from Cinderella Travels. It was a single source method. And again, are the non-compliance issues very similar?
Yes, they are very, very similar.
What were the main non-compliance issues you can tell us briefly?
Yes, fundamentally, it was above the threshold for single source, because the amount involved is more than 200,000. Threshold for single source, of course, is 20,000.
Louder, please.
I mean, the amount involved substantially exceeds the
Yes.
threshold for single source. One, but they decided to single source it. One, so it means they needed prior approval from the authority.
Yes.
Yeah, this was never done. So in essence, it means the processes were not followed. The processes were not followed. All the orders is a replica of the previous queries.
And in addition as well, it was being conducted by people that are outside
Yes,
the
yes.
procurement unit.
That's what I mean by a replica of the
Yes.
previous queries.
I'm sorry.
Council, Chair, the
Absolutely,
Vice
yeah.
Chair wants
Thank you.
to-
Mr.
Yes, sir.
We've been hearing a lot about non-compliance in procurement.
Yes.
In a situation like that, do you have any institutional mechanisms in place to sanction for non-compliance? Do you surcharge? Do you recommend to the institution to take action, or what?
Okay. Issues of once an activity is rendered or classified non-compliant, it means there is a violation. It means there is a violation. Though the Act made provision for punitive actions, specifically Section 69 make provision for punitive actions. However, as far as GPPA is concerned, as far as our mandate is concerned, we report all our findings to the National Assembly, especially the FPAC and the PEG. All these things are generated, reports submitted to them for further action. That's our reporting line, in addition to our line ministry. But generally, the issue has been an issue of enforcement, has been an issue. But all these things, the recommendations are always submitted. I think, Madi, you want to come in here? Okay. He just reminds me that in addition to the National Assembly and our line ministry, we also report to the Auditor General.
Yes.
Yes.
That is where I wanted to draw your attention to. In the Act, that is Part 10, Section 56, subsection 1 and 2 says that procurement activity shall be subject to regular auditing by the Auditor General to ensure that the public funds are expended for their intended purposes and with a view to maximizing value received by the public purchaser, ensuring that proper and accountable systems are in place and adhere to, and identifying any weaknesses in procurement. The Auditor General shall conduct annual audits of the procurement activities of entities and shall furnish copies of reports on the audits to the authority upon request from the. So here my question is, over the years, have the Auditor General been conducting audit exercises on your activities?
Do you mean specifically on our activity as an authority or audit exercise on institutions?
Yes, just like is provided for under subsection 2 of 56 under the Act, which says the Auditor General shall conduct annual audits of the procurement activities
Yes.
of entities and shall furnish copies of reports on the audits to the authority upon request from the authority. Do you have those reports from the Auditor General?
Formally, there were moves taken to have a kind of an MOU with the National Audit Office so that we share our reports. But in practice, that has not been very forthcoming, the sharing of reports generally.
Thank you. Yes, Commissioner Joyner wants to ask.
My question is, there's a lot of provisioning or policies as to what they should do and what they have not done, or what they should do in particular. For me, I'm sitting here thinking, yes, they have failed to do X. Your role is to do A, B, C, up to X. Now we are left with Y and Z. And the Y and Z for me is the punitive action when they fail. Do you think that is hampering your oversight function?
Yes, as I just alluded to, the punitive actions are already in the Act, but we are not mandated to do the enforcement. So that's why, in fact, it's a concern for us. That's why, in fact, sometimes it has always been said that GPPA is a toolless bulldog. Understand? But that's the issue. There is an issue of enforcement generally.
Coming back to now, it seems as if enforcement is taken out of your plate. It's given to somebody else. From what you are saying, you can report, you can do, but you cannot enforce any punitive action. Where is that action taken to?
Yeah, the actions, the recommendations, they are taken to, as I said earlier, to the National Audit Office, to the National Assembly, specifically the FPAC and the PEG, and to our line ministry, Ministry of Finance and Economic Affairs.
Now, to follow up on that, do you as an institution follow up on your recommendations to where you have submitted your recommendations?
Yes, sir. That's why we are aides to the National Assembly. We are represented in their sittings of these committees, and we make presentation. We highlight the issues, the challenges, the recommendations, and the National Assembly is to decide and take it further from there.
So let's put it this way. So the National Assembly is being blamed for the non-enforcement of your recommendation, or the Auditor General's office?
I have a different opinion, sir.
Okay. What's your opinion?
Because we don't know the issues at the National Assembly. We don't know what are their constraints. So all that we can do, as per the law, is to submit, then accompany the submission by our presentation, our presence, clarification, etc. Thereafter, what happens, we are not privy to what happens.
If you are complaining or stating that you don't have the enforcement powers, that is vested into another body. But that body is making you to toil and work so hard to come up with a recommendation. And you just put it on their desk and say bye-bye. And I am worried because it seems as if it's a futile exercise that you have been engaged to. Because if you can make a recommendation and they are not being adhered to, or no follow-up is made for the enforcement, where you have, for example, you are buying calendars, 400 calendars or whatever, and to 500,000. That's a humongous amount. So it seems on the average, it's a calendar, one calendar will cost you almost 1,000 plus per calendar, 1,250 per calendar. And if you've seen that as a abuse of authority, and you say, okay, this is what I have found, this is what now I'm giving it to you, whatever you do, I'm okay. If you don't take action, I'm okay. You take action, I'm okay. But monies have been spent with your institution to come up with these findings. I think the whole purpose of this, as you can see, is transparency and accountability. We want them to be accountable for some of their action. If you believe that your enforcement role should be given back to you so you can enforce what you have seen, or do you want to have a separate body to enforce your recommendation? Because I think the bureaucracy is just too much. We have to shortcut this bureaucracy and say, we have found out, to the best of your ability, this is wrong. We believe the single sourcing has been violated, or the request for quotation has been violated. You know, things have been, I said it the last time, prescription has been given to a dead man. So why do we still have something like the GPPA? That is the bottom line of my question.
Thank you, Commissioner. I really understand where you come from. But I really want to limit myself within the confine of the Public Procurement Act. The punitive clauses...
Just a second. Do you agree with me that is frustrating?
Sorry?
Do you agree with me that this position is a frustrating position?
I have a different opinion, which I really want to present.
It's a yes or a no. It's simple. Is it? Do you agree or disagree?
That's what I said. I said I have different opinion.
Then you disagree?
Yes.
Okay.
Yeah. Because as far as I am concerned, because it's about the country now, it's not about GPPA. What is important here is to have a mechanism for enforcement. Whether that mechanism is coming from GPPA or from a separate body, as far as we are concerned, we are indifferent. What is important here is having an enforcement mechanism, which is grossly lacking in the Act. And the Act also, to some extent, is very silent. These are the provisions, the punitive clauses, etc. We make our recommendations. It's submitted to the rightful authorities. But I am not sure, because the law here, the Public Procurement Act, has not mentioned specifically who is in charge of enforcement. It's not mentioned in the law. It has not mentioned it anywhere specifically that A, B, and C are in charge of enforcement. So to some extent, as far as my interpretation is concerned, it is silent. We don't have the enforcement powers. I'm not sure whether the other bodies I have just mentioned here, the oversight bodies, whether they have the enforcement powers. But all I know is we report to them, all these issues are discussed, and they are responsible for taking further action after our report. Thank you.
Council, sign.
Mr. Tamura, what measures does your office have in place to verify the accuracy of quotations and contracts submitted by suppliers?
Sorry, can you please repeat that? I don't know.
What measures does your office have in place to verify the accuracy of quotations and contracts submitted by suppliers?
Yesterday, I said here about independent suppliers. Quotations, most of the time, when they are solicited, it depends on what thresholds or what level, whether they are submitted to GPPA at prior approval or at post. If it is submitted to us at prior approval, the quotations are reviewed, and most of the time, we subject those quotations to due diligence. We try to verify. We look at what we call the collusion red flags to see whether these quotations are really authentic or they are not authentic. Are they coming from the right registered suppliers as per our tracking system? Does this business exist, etc.? We do a lot of background work just to ensure, as part of our quality assurance, that these quotations are really authentic. We do a lot of that. Though I understand there is no perfect system generally, but we do a lot of background checks to ensure that these quotations are really authentic before we take any decision.
And where you seem to disagree with the quotation, what do you do?
Very simple. Once we disagree with the quotation for whatever reasons, we write back to the institution that these quotations are not authentic, or whatever the problem is highlighted, and we advise them accordingly.
Madam Chair, I just have a few questions before, in case you have any more.
Okay. Yes, you can proceed, Mr. Jete.
Thank you, Chair. The Commissioner's question to the Director as to whether what powers
Can you please speak through the mic?
what powers the authority has. I just want to cite Section 94 of the Act, which says offenses related to procurement, and then Section 95, penalties and sanctions that can be imposed on the offender, including debarment, etc., etc. So there are actions that the authority can take.
Are you quoting the 2014 Act, or which of the Act? Because the Act I have before me.
I beg your permission, Chair. This is the 2022 Act.
The 2022, has it been promulgated?
Yes, it has.
Thank you.
But this was it's 2022, so it does not maybe take yes.
For ease of closure on my comment on that, could you just read for us what it says on the penalties and which body is it rested on or vested on?
Penalties and sanctions. Where a person is convicted under the Act, he or she is liable to a fine of the amount of loss caused to the public body and shall in addition be imprisoned for a term not exceeding 10 years. 2. In passing sentence under Section 1, the court shall consider such mitigating factors like the recovery of the loss incurred or the property loss. 3. Where an economic operator is found in one of the situations described in Section 24 and 25, the procuring organization may take the following measures against the economic operator. 1. Reject the bid. 2. Declare the economic operator, including his affiliates, ineligible for award of public contracts, either indefinitely or for a stated period of time, including debarment as defined in Section 92. Yeah, the list goes on. Can I continue? It's a long list.
I've read, it seems as if the courts are part of the enforcement procedure. You have to take them to court. And when they are found guilty, then the court will impose the sanctions that you have just read. I just wanted to know whether it is vested with the GPPA or it's moved from the GPPA to another oversight body or another institution, which you have now read to be the courts. So it means cases have to be filed.
Yes, I think here is referring to the institution.
Oh, here. But
yes.
I thought I had the word courts.
Yes, it's referring to the procuring organization, the institutions.
Taking them to court.
But also, like, it's a long list, and I think in our interpretation of some of these provisions in the regulation, the new regulation, the 2023 regulation, I think there's a point that where we said such malpractices, corruption, or criminal activities shall be reported to the Auditor General, and the Auditor General shall take punitive action. There are penalties that he can impose on the offender.
I'm not so
but this is the new act and the new regulation.
Yeah, I'm not so sure the Secretariat has a copy of that 2022 regulation. I think we have only 2018. Lila.
They have the act and the new regulation.
Yes.
Thank you. Am I correct?
Yes.
You have the
Yes.
act and the regulation. They do
not
have
the
access to-
regulations, the act.
Okay, the act. Okay.
So I was just going to ask, when was the act passed?
The 2022 Act, you mean?
Yes.
It was November 2022.
November 2022. So it's been operational since then, essentially.
Yes, Council.
Now, under the provisions about debarment of economic operators, have you had any instances where you have debarred contractors for some sort of malpractice?
No, Council. Just want to explain. However, the Act, though enforceable, but at the moment is without a regulation. My DG made mention of the regulation, I think yesterday or the first day, that it is being validated and the process is ongoing to explain some of the procedures to follow.
But then the Act is also kind of clear about what you can do in respect of debarment. You don't need the regulation to be able to do that.
I understand. It's already adequately provided for in the Act, the regulation, just to explain things further.
Yes.
But we haven't got any instance of debarment proceedings so far.
So that's what I'm asking, because what Commissioner Joyner was asking you in respect of sanctions that you can impose, you have this, and if you're saying that there are, you're a toothless bulldog and things like that, it's contrary to what you're saying now, because the Act has been passed since 2022 and it's now July of 2023, and I'm sure that you've had instances between this period where there are contractors that have done some sort of malpractice, or there are issues that you have noticed that you could use this provision, but you said that no instance has arisen.
Yes, I think what I meant was the actions, because debarment proceedings does not start from GPPA. Start from the institution, just like complaints, just like debarment. So it starts from the institutions and then it continues.
So let me just read section 92, which is debarment of economic operators. So one, it says the authority, and that is GPPA, shall protect the government from actual or potential harm by excluding a potential bidder or contractor from participation in public procurement for a minimum of 1 year and a maximum of 5 years after A, giving 10 working days notice to the supplier or bidder involved of the cause of the proposed action. B, giving the potential supplier or bidder 5 working days to respond to the proposed action. And C, consultation with the Complaints Review Board and the affected procuring organization to consider all the facts of the case. Now, in an instance, so this is talking about a potential bidder or contractor. So it's not necessarily one that has already been entered into. You have a list of all these contractors. So you have an idea of instances where there have been some malpractice or some issues, right? So you would know that these are bidders that have issues. Now, where I don't know, how do you call it, the pre-qualification or whatever it is that has come to you as a result of applications from the procuring organizations. There are instances where you would see some of these bidders listed, right? What happens when you know that there have been past instances where these bidders have done some sort of malpractice? Do you write to the procuring organization to let them know that there are issues with this bidder? And if you do, and they don't do anything about it, what does the authority do?
Yes, as I told you earlier, these are potential bidders, and the potential bidders are those that have not even actually participated in the process. These bidders, the institutions directly deals with the bidders, and if there are issues, most of the time we get the communication from the institutions. There could be instances where GPPA as an institution, we may have an issue with a particular bidder. That is GPPA as an institution now. And I think I can make reference to a particular issue. We had an issue as an institution with a particular bidder, and the case was reported to the police, and the matter is before the police. But at a global level, institutions, procuring organizations, the fact that they deal with the bidders, they know the issues, they know there are problems, if there are violations, because they conduct the procurement proceedings. That's why they come to us at every stage of the procurement proceedings. So if there are issues, we expect the communication to come from the bidders. And the section you have just read here, if the communication comes from the bidders, then investigation starts. The debarment proceeding starts. And once it starts, this could be the conclusion. Debar the bidder finally, suspend the bidder, etc., etc. But we haven't received any issue of this nature so far. But as an institution, we had a case like this, and the matter was reported to the police formally, and it is under police investigation.
So where you have instances that a procuring organization has entered into a contract with a contractor or a bidder, and for some reason, the bidder did not carry out his duties under the contract, and the contract was terminated. The procuring organization will give you notice that, or ask for approval to cancel the contract, right? So in that instance, do you try to find out why they did not fulfill their obligations under the contract? And if you do, and it is obviously, if it's a reason that, well, there's no justification for it, essentially, the act allows you to debar them for a period.
You are talking about cancellation and debarment here.
So, if the cancellation of the contract, I'm not talking about the procurement process, the contract is either cancelled, voided, whatever it is that, there's a breach by the contractor.
Contractor, yes.
The procuring organization will write to your authority to inform you of this fact, and they will also ask for your approval to
cancel.
Right?
Yeah.
So in such an instance, will your authority try to find out what the reason for the breach is? Let me ask that first. Would you try to find out what the reason for the breach is?
Yes, most of the time we find out what the circumstances are leading to that potential termination. In most of the cases, we have instances of that. We do invite the procuring organization, sometimes the contractor, for further checkup, verification.
And when you verify and it turns out that the breach, there's no excusable reason for the breach by the contractor, what happens?
Yeah. Most of the time, because there are conditions for cancellations. You cannot cancel because of the sake of cancellation. Mm-hmm. You can only cancel if you satisfy some of the conditions, including, of course, contractual breach, whatever. If those conditions are met or if they are satisfied, after our due diligence, we give approval for cancellation.
No, I don't think you're getting what I'm saying. No. There's a contract already between the contractor and the procuring organization. So let's use KMC as an example. Okay. There's an agreement between a contractor and KMC for the building of, say, their office building. The agreement is supposed to be for a period of 1 year. The KMC is supposed to pay the contractor a certain amount in stages. So they've paid the first installment. It is for the contractor to now start the building up to a certain point. The contractor has failed to do this. KMC has written, the contractor still hasn't done what they're supposed to do. Now, that is a breach of the contractor's obligations to perform the contract. KMC decides that they're going to cancel the contract because of that breach. KMC writes to your authority to say, this is what has happened. The contractor has breached the agreement and we're terminating the agreement. We need your approval to terminate the agreement. That's what they write to you. So, like that, you now know why they're terminating the agreement. You grant them approval to terminate the agreement. What happens to the contractor? Because he's listed in your database as, he's registered in your database. Other people are going to try to work with him without knowing that this is something that has happened. So in such an instance, what happens to that contractor?
Once the contract is terminated, there is a particular form called 041. That's the record of supplier performance assessment. You have to assess the performance of the contractor, submit it to GPPA. In the event you need debarment proceedings to take place, you also initiate that debarment proceedings. However, most of the time we always refer them to the contract document. What was the contract document? What were the provisions? So they should always resort to the contract document as to the next step. But as far as the procurement law is concerned, the fact that we approve the cancellation, it means the contract has come to an end, and they should resort to the contract document, to the provision, to guide them as to the next step.
So what I'm asking you is, what you're saying right now is KMC's rights under the contract, what they can do to remedy the situation. I am talking about specifically what happens to the contractor in terms of GPPA. They are registered with you. The idea is that they're registered with you, so they've met certain preconditions, blah, blah, blah. Now, your act is saying that where a contractor has failed to perform under their contract, debarment proceedings can be instituted, or debarment can happen. Now, you've just indicated a process where Form 41, is it? What regulation is that under, the old one or the new one?
The 2018.
2018, right? So, this act does not say anything about whatever form that you're going to use, etc., but it says that the ground for suspension or removal is failure to perform in accordance with the terms of the conditions of the contract. So the procuring organization has its own rights under that contract. But why I'm asking is that you're supposed to be saving the government from actual or potential harm by excluding a potential bidder or contractor from participating in public procurement for a period. The idea is so that, you know, if they were not up to standard, suspension for a period will maybe help them regulate themselves better for when their suspension ends, so that if they enter into contracts with any government entity again, maybe they'll do better. So that's why I'm asking, in such a situation, what happens? Because you have powers under the Act. Have you used these powers?
If there are no debarment proceedings, normally we always recommend for self-cleaning.
Okay, what's that?
For self-cleaning, like it's very possible the contractor had issues, whether commitment issues, competency issues, whatever. So we ask that, or we advise that the contractor is somehow isolated to work on the weaknesses that led to the breach of that contract, to improve on where it was about competency issues, where it was about contractual issues, whatever. We advise that he works on those issues. If it means change in management, change in equipment, change in leadership, whatever. So those are the self-cleaning exercise that we recommend for the contractor, just to improve on the weaknesses, to allow him participate in further procurements.
So essentially, he won't be suspended or debarred. He'll just be asked to regulate himself pending another contract with another government entity.
Yeah, because a breach of the contract may not actually lead to suspension. It depends on the gravity of the...
So I understand that.
Yeah.
But the scenario I gave you is a potentially big breach.
Yeah.
So it's that kind of scenario we're talking about. Simple, small breaches are not that.
Yes.
But in situations like that.
In situations like that, we expect, let's say, KMC in this instance to initiate the debarment proceedings, and we take it up from there. But
where KMC has notified you, why do you require them to further institute debarment proceedings? You have the power to do it.
Yes.
Because this is not an obligation on the procuring organization. They have their own obligations under the Act, but this is directed at your authority.
Yes. The notification from KMC, for example, in this case, was for cancellation and not for debarment.
I understand that, but they've told you the reason for the cancellation.
Yes, that's why...
Does that not prompt anything in your authority?
Yes, as far as we are concerned, as far as we understand the provisions and what is in practice normally, the debarment proceedings comes from the procuring organizations, and we take it up from there.
So that's what I'm saying. That practice is under the old regulation and under the old Act. This is a new Act. But then you said that there's been no sanctions under this new Act by the authority within this, 8-month period?
Yes.
Okay.
Just a follow-up on that. Do you, as we speak, have a list of potential suppliers or whatever services to the government authorities, that you have a list of people that you have debarred or don't touch these people? Do you have a list?
No, there is no list.
Since you started, there is no list?
No list, sir.
And you've had all these complaints about non-suppliers supplying the wrong things and all of that, and you have not initiated any process of putting them on a list, so that if SOE1 wants to do business, he will check the list first and say, oh, I cannot do this with this person, with this person. So it's still a carte blanche, as the French would say. It's an open ticket, yes, which I could also fall into the same trap that caused them to have a flag raised on their behalf. So you don't have a list at all?
Yes, as far as
okay.
Our records...
Okay, that's okay.
No list so far.
Okay.
Yes, you can.
Mr. Tambura, is the 2018 by the National Assembly?
Yes, it is replaced by the 2022 Act.
Yes, so let's not refer to the 2018 Act, because it's been repealed. It doesn't stand anymore. because it's been superseded by the 2022 Act. So let's confine ourselves on that Act. That's one. Two, I'm trying to understand something which is not very clear. One is the procuring institution. That is where the documents are emanating from. And they are dealing with the contractor. Now, it is difficult for me to understand that the procuring institution can take an oversight function to regulate the contractor. I think that should be the job of you as the oversight. Do you understand what I'm trying to say? You understand me? Because if the procuring institution is a conspirator to the bidding process, you are there as the regulator to raise the flag, not them. They cannot.
Yes, institutions deal with these suppliers, these contractors directly. Remember, there are certain procurements that are never submitted to GPPA, sometimes regardless of the value. In this case, how do we in fact know there is an issue? So the institution,
I'm trying to talk of the things that are coming to you. What they do at their level to do whatever, to give out contracts. I'm not talking about that one. That one is already illegal. I'm talking of those that comes to your office. Those are the ones I'm trying to confine myself on.
Yes, Commissioner, I understand very well, but as far as we are concerned, we have not received any formal complaint from any institution as to A, B, and C, and therefore there is a need for debarment. So that's the challenge.
Okay, before I give the floor to Mr. Jete, to further clarify the issue, because lead counsel was trying to find out, pursuant to the new act, the powers you have. My question is bordered on the compliance review that you do, because the compliance review have revealed that institutions were not complying with processes and procedures, and they were dealing with service providers and contractors, etc. And you have had the cause to make recommendation and to highlight the fact that some of these people did not comply or did not perform. So in this instant, the new act came into being in 2022, and you have, we have admitted in evidence reviews that are up to 2022, and there has been lapses, serious lapses found. Institutions have been found wanting in their compliance. So I think what council was trying to bring forth is that since you have you've given evidence that you have a database, the reason why you have a database is to ensure that if a public institution has to deal with a contractor, you are able to trace, that contractor. You are able to ascertain that at least he has basic minimum capacity to do the work or to provide for the goods, and they may comply with the specification. So now my question is, why are you not using the compliance report that you are generating to create a list of potential contractors that you may flag to indicate that these people, you understand, because you are spending public funds, you must guard against using these people, even though your authority is given the mandate to make sure that there is a level playing field for all operators. But it is also your mandate in the Act to make sure that those potential operators, you understand, if they are found wanting, it should be classified as people that are found wanting and should not deal with public institutions in order to avoid wasting public funds or using it inappropriately or providing goods and services that are not commensurate to what the institutions are looking for.
Thank you very much, Chair. I think that's a wonderful suggestion. It is noted, and it is adequately captured in the current regulation as we speak, because it is also a concern to GPPA, generally is a concern. But we just want to confine ourselves to prescribed procedures. The issue of debarment is mentioned in the Act, but the nitty-gritty, the details, is captured in the regulation, which is yet to be validated. But the concerns are really noted, and the recommendation, inshallah, will be taken care of.
Yes, but that is why lead counsel was trying to put across to you that you do not necessarily need to wait for the regulations, because the Act is very specific and is very clear as to what you can take as your role and responsibility in making sure that you are able to protect the institutions from dealing with enterprises that may not deliver, you understand, on their contracts. Thank you.
Thank you, Chair.
Yeah. You may proceed, Counsel. Okay. Yes, Mr. Jete, sorry.
Thank you, Chair. I want to attempt to answer or clarify 3 questions. I think 2 is from the lead counsel, and the third one is a joint question I want to clarify, raised by lead counsel and Honorable Silla. The new Act 2022 certainly came during my tenure, and when I was initially appointed, my first preoccupation was with this Act to work with National Assembly and also the government and DPPA to pass this Act, which did happen. Now, your question was, your original question, lead counsel, was, can the authority, DPPA, debar? Yes, it can, as per the provisions of the Act. Your next question was, have we debarred any economic operator? During my tenure, no. Extending that, one incident, however, based on the gravity of the situation, there was a public tender where one economic operator, we allegedly received information that this particular economic operator was going around attempting to bribe public officials in order to win the contract, and we became aware of that. And so what we did was to write to that company, and we have the letter. We wrote to the company and the CEO, informing him of his actions and that it is illegal. And if he does not cease, he will be debarred. And the letter was copied to the Honorable Minister and also the procuring organization that issued the tender. So we came close, and the contract was cancelled anyway. It was a huge contract, over $300 million. Obviously, that was the tune of the contract. So yes, we have not debarred, but there's a situation that came during my tenure where we were almost on the verge of debarring a company. Now, the third one is...
before you proceed, sorry for interjecting. Having come close to debarring, have you taken the step now to debar that particular company?
No, we did not debar the company. We only warned him that if he does not stop trying to bribe public officials, which we were investigating because we received the information and we verified, of course, but so we wrote to him that if they don't desist from trying to bribe public officials to win the contract, they will be debarred. And it was a warning to desist from the act. So if they had gone on, if we received information that they're insisting, they will be debarred. But that's where we rested that. And also, the contract, we did not approve the contract anyway. The contract was cancelled. The bid did not proceed because of certain issues.
Now, what will guarantee that he may not be a potential contractor for subsequent coming contracts?
The possibility is there, and if that happens, then he will be debarred.
Thank you.
And the last one I want to clarify is the authority should not and shall not wait for economic operators to bring proposals to debar or to write to inform us or to precipitate the authority to debar where we need debarment action needs to be taken, because the act is very clear. The act does not say that we have to wait for the economic operator to bring it to us. If we are the regulator, and if we come across a situation where we feel we need to take action to debar, we will act accordingly without waiting for the economic operator, as per the law, 2022 Act.
So that was my concern because Mr. Tambura had said that it needs to be initiated by the procuring organization. And I think my next issue would have been in an instance where the economic operator is trying to bribe a member of the procuring organization, do you think that the procuring organization will bring that issue to you? Because if they're involved, it's not likely that they will bring it to you, and so you probably would never know or never initiate debarment proceedings because you don't know officially.
Yes, I understand. These are concerns and policy issues. Like the reference he just made, we got the communication from an institution. That's what I meant. Because normally, the communication comes from institutions. You understand? Even this one, it came from an institution. So then we take the next step. That's what I really meant.
Madam Chair, I don't know whether you have questions. I'm done.
Yes, you may proceed, Council.
Anyways, thank you very much, Mr. Jaite and Mr. Tambura. Is it Tambura?
Tambura.
Tambura, your surname seems to be very, very unique.
Thank you.
So we just proceed. There are a few issues that we should discuss regarding the procurement conducted in BCC. The other one, we have discussed the issue of procurement of air tickets, the amount of $276,768 from Cinderella Travel Agency. It is a single source method. And the non-compliance issues, you have discussed, they are very, very similar. But one of them is that there was no examination and receipt committee appointed to inspect or verify that the procurement was also conducted by people outside the procurement unit. And no prior approval was sought. In fact, they have violated most of the requirements. Do you see that?
Yes.
Now, when will you be able to avail us in all these situations? Because it has highlighted, in fact, in all of the situations that this procurement was done or conducted outside the procurement unit that was mandated to conduct these purchases.
Whether we should be able to avail you what exactly?
The names of the individuals that conducted these transactions.
Okay. I said we'll endeavor to provide it. We'll endeavor to provide it.
The other one is on page 34. We almost done. It was in relation to a contract that was awarded to Basen Enterprise. The amount is $662,000, $156. Page 34. Okay. The non-compliance issues are: number one, the request for quotation was not used in the soliciting of the quotations from suppliers. The form 101 was not used. The second, no evaluation criteria were communicated to the potential suppliers. No inspection and acceptance carried out to verify the goods. The procurement was above the threshold. There is no evidence to show that the works were inspected. The procurement was done outside the SPU. Quotations collected by a group that visited Ostenda with the Lord Mayor. The right procurement process was not followed. Now, with respect to this Basen Enterprise contractor, in the amount of $662,106, we have seen that no requirement was followed. But then two key issues that you highlight were that not only is the procurement conducted by people outside of the SPU, that is a special procurement unit, but there were individuals who traveled with the Lord Mayor, or is it Mayoress at the time? This is 2019.
Yes.
Yes. So, do you know? were you given the list of the people that traveled with the Lord, with the mayors?
I think the list is available. We should be able to get the list.
And what was this procurement, what was it specifically for? Do you know?
Because these are specific findings, the specific nature of the procurement was not captured in the report, but it falls under works procurement, and the files should be able to verify exactly that what these are just specific things. We just wanted to highlight certain violations. That's why we referred them as specific findings.
Now, how about the same page, procurement for or of refurbishment of market toilets? Simple works is the category. Amount $179,500 is awarded to Dembas Trading. It's a request for quotation method. And there were also similar non-compliance issues. Is that correct? So
yes, sir.
Again, the rules or the requirements were not followed.
Yes, sir.
The last would be $41,000 is awarded to one Malik Mendy, the supplier. Again, no requirement being complied with.
Yes, sir.
What was the rating in 2019 with respect to the compliance and performance rating scoring for BCC at the time in 2019?
Overall, the rating was 40%, which denotes non-compliance.
What is a 40% rating in compliance review?
Basically, it means overall it means non-compliance to the public procurement.
So it's really extremely poor.
Yes, sir.
So in 2019, the compliance review disclosed in my findings here, based on the interaction, that in fact there were will you say that there were gross violations of the requirements as per the Act and the regulation?
Yes, as per our findings, the indications are that there were big violations of the provision of the Act and the regulations, which were our benchmark for this review.
And time and again, most of these key findings are that, number one, these procurement activities were in fact not being conducted in a proper manner. That is, maybe there is no approval from the contracts committee, correct?
Right.
And then you maybe in some situations or most situations there are no specifications.
Right.
And you have the pre-qualification as well. So
right.
All these requirements were mostly not followed.
Yeah, most of the
so
requirements.
In BCC, what you have basically is just business as usual. Individuals deciding just to procure at will without following due process.
The concern, one of the fundamental concerns is the conduct of procurement by members outside the procurement unit.
Yes.
If that is done, it raises a lot of concerns. And also,
what are these concerns that it will raise? You said a lot of concerns. Just give us a few of the concerns.
Fundamentally, whether the processes and procedures were followed. Because members outside the procurement unit, most of the time, are members who are not expert in the procedures. But the procurement unit, the expectation, we don't even expect, let's say, the procurement officer to be an expert in all areas. But he is expected to be an expert in the procurement procedures, a procedural expert, that is expected. So if members outside that are conducting procurement on behalf of BCC, that is a case for concern.
Yes.
And it has manifested itself several times, the issue of above thresholds procurement, the issue of inadequate supporting documents, and so on.
Yes. In fact, I'm more interested in the concern that you have now. Just to conclude on this report. Primarily, when you say you have, it is so much concerns, that it will be probably a bit vague. Then one may be tempted to start thinking, is it in relation to being at risk of misappropriation of funds, corrupt practices, fraudulent activities, and so on and so forth. So basically, can you be more specific regarding what are the normal or possible concerns that it may raise when you have people who are not experts in procurement, who are not members of the unit in fact, but probably because of their position, they decide to engage themselves in procurement activities?
Okay, let me narrow it down. Let me narrow down the concerns to 3. One, potentially, there is potential conflict of interest. 2, there is potential bid rigging or collusion.
What do you mean by bid rigging?
Basically, it's about bidders coming together to do bidding, but in favor of one or the other. When you compromise all procedures to ensure a particular bidder wins, because sometimes it happens. Let's say 3 bids are collected or 3 quotations are collected. You have quoted 1 million, the other quoted 2 million, and the other quoted 3 million. 3 bidders, 1 million, 2 million, 3 million. Naturally, the one with the highest stands a big chance in winning in a situation of bid rigging. Because what happens most of the time, A and B may decide to withdraw. If A and B withdraws, the highest stands a chance of winning. Probably, because of its bid rigging, they must have discourse so that they can share the profit. Just an example of bid rigging.
Yes.
Yeah, so these are instances that happen, so that's why I say let me narrow it down to 3. Potential conflict of interest, because members of outside the procurement unit, they are not expert. What motivated them to go in and conduct procurement? What motivated them to conduct a role that is not theirs?
What would you think as an expert would probably be the motivating factor?
That's why we say potential conflict. That's conflict of interest. That's where the conflict is now.
Conflict of interest may not give rise probably to a fraudulent action. I may be conflicted.
Yes.
But perhaps there may be no fraudulent transaction. Yeah. Now, that is one aspect of it. Yeah. Maybe probably I know someone or a supplier, and I just want the individual to have advantage over the others. That's one aspect of it. Yeah. But are there any high risk of fraud and any high risk of corruption in these instances, when there is blatant disregard of procedure and requirement?
That is a possibility which can be confirmed with a further.
No, does it exist?
Our review does not establish whether it exists. What is a possibility?
It's not about your review. Does not even does your review conclude on the fact that there is conflict of interest? There may not. Your review will outline there is a possibility of a conflict of interest. Is that correct?
Yes. If you check, if you look at some of our the implications, it indicates potential conflict of interest.
Exactly, but it does not conclude on conflict of interest.
Yeah, because a further review will have to indicate that.
Now, is there a potential fraudulent activity or corruption based on the situation?
That's what I said. There is a possibility.
Yes.
It simply means the potential is there.
Yes. Yeah. Now, Madam Chair, that we have done, we have discussed the issue of the report regarding the year ended December 31st, 2019. I'm not sure whether we are it's time for break. If not, we have some documents that we want to tender through the witness in evidence as an exhibit, unless there are other questions.
There is no, it's not yet time for break. But before we proceed, before you start that, I just want to find out from Mr. Tambura, on the same report, it is the procurement of rehabilitation of Crab Island, it says procurement of rehabilitation of Crab public toilet. It said the category is works, the amount is 662,156. And the contract was awarded to Basen Enterprise. And the method of procurement was RFQ, that is a request for quotation. Here my question is, when you do your reviews, do you normally find out whether the jobs that were paid for, was it executed? Because having read the findings, I couldn't find anything in the findings that suggested that the works were either done as per contracted for or otherwise. Can you enlighten us here?
Yes, Chair. Most of the time, when we are on review exercises, we also do some background checks, but normally it's on sampling basis. I'm not very sure whether this particular one it was done, but if I can always confirm it in our records whether this particular one it was actually done. But we do it once a while. If there's an issue and we had concerns, we go further to verify, to actually see the status of the work, etc., vis-a-vis the payment made, whether they commensurate, etc. We normally do that.
But in this circumstance, you did not verify whether the works were actually done or not.
So that's why I said I have to.
You have to check.
I have to
All right.
establish that. Yeah.
Yes, please let us know if you verify when you come back tomorrow. Thank you. You can.
Can we also know the location of Crab Island public toilet? Where is it?
Okay, we'll do the confirmation.
Please.
Any other questions from the commissioners?
Yes. Now we have noted also that the refurbishment of market toilets, in your findings, it should be on page 35 of the 2019 compliance review report. Have you seen that?
Yes, ma'am.
Yes. My question here is that in your findings, you have indicated that there is no evidence of the completion report in the procurement file, as there was no inspection committee. You might correct me if I am wrong. I am assuming that what the finding is saying is that you couldn't see any evidence showing that this refurbishment was done. Is that what the finding is talking about?
Any evidence to indicate that the refurbishment was completed?
Yes.
Yes.
Okay, thank you. And for the procurement of the berets,
yes.
There was nothing in the recommendation to show that whether what is in the recommendation is that that is point 5, the last point. I think. Yes, the 7th point. What is indicated is that the procurement was conducted by people outside the procurement unit, which you have extensively explained.
Yes.
And below that paragraph, you have indicated that there was no evidence of delivery notes.
Yes.
So, for our understanding, it means you are not certain whether these berets were supplied. Is that what it means?
We are exactly so.
Thank you. Thank you.
Thank you very much, Madam Chairperson.
Yes, we can now proceed to have the procurement documents all admitted, and you can proceed on your reports when we come back after the break.
As the Commission places.
Thank you.
Now, Mr. Jete and your able assistant, we have some files that you have forwarded to the Commission. We will want to show you these files for identification before we apply to have them tendered in to the Commission, okay? Do you follow? They are in relation to compliance files
Yes.
from various area councils.
Yes, sir.
So we will start with Banjul City Council. I have here with me Banjul City Council file 6/20. How do you pronounce it? Is it 6/20 or 6 of 20? 620. So Banjul City Council file 620. Can you please identify this file? Honorable Registrar, can you please come? I will now ask the Honorable Registrar to just show you all the files. You can identify them, and please, you can call out each file and the number. Yes, so what is the number of the file that you have with you?
And before you proceed, please help us use your terminology so that we can get the evidence correct.
What is the number of the file you have with you?
Yes, this is BCC 620.
BCC 620.
So basically, just for interpretation purposes, it means this was the 6th submission in the year 2020.
Thank you very much. With respect to Banjul City Council.
City Council, exactly.
And the second file?
The second file is BCC 318.
318?
Yes, BCC 318.
The third submission of the year 2018?
Yes.
Please move to the next file.
This is BCC 520.
520?
Yes.
And which one is the next?
This is BCC 220.
220?
Yes.
Is there any other?
Yes, sir. This is BCC 420.
420. Yes, please proceed.
This is BCC 120.
120.
Yes, sir.
Is that the last one?
No, sir. This is BCC 322.
322.
Yes, no, 320, then in bracket 2. That's the second of 320.
And then?
Can I get that one correctly? You said BCC 3?
This is BCC 320.
In bracket 2.
In bracket 2.
Okay.
Okay, that's what I have. Yes?
Sorry, he has just drawn my attention to the BCC 320. Then the other one is BCC 320. So that one is 1, this one is 2.
Okay, BCC 320 in bracket 1.
Yeah, we have 1, and we also have
and the other
2.
one is in bracket 2.
Yes.
Yes. Any outstanding?
Yes, this is BCC 1.
BCC 1. 1 of
20.
20. Please proceed.
Sorry, we already have BCC 120 as the first, second, third, fourth, fifth, sixth.
As the sixth, yes.
Yes.
Do we have 2 of 120 or is it just 1?
Let me just confirm that.
Or is it the same file you have called earlier?
I think I did not. We only have 120.
Yes, so you called it twice?
Maybe. I'm receiving the files from him.
Yes. There's only one file of one in the year 2020.
Okay, it's okay now.
No, just for your record, there's only one file of BCC 120.
Yes, there's only one file of BCC 120.
And then, is that the last one or are there any other?
We have BCC 218.
218?
Yes.
Yes, please proceed.
We have BCC 118.
BCC 118?
Yes.
Yes, is that the last?
No, this we have BCC 121.
Volume 1. Can you please confirm whether the total number of the files are 12? How many files do you have, Honorable Registrar?
11. I have here 11.
11 files altogether?
Yes, recorded here.
So let's take it one at a time. The first is BCC 620. Do you have that?
Yes, sir.
The second is BCC 318. Do you have it?
Yes, sir.
The third, BCC 520. Is that correct?
Yes, sir.
The fourth, BCC 220. Is that correct?
Yes, sir.
The fifth, BCC 420. Is that accurate?
Yes, Council.
The sixth, BCC 120. Is that accurate?
Yes, Council.
The seventh, BCC...
Sorry, Council. It's drawing my attention to... I think it's the same issue here, the BCC 320. You know, I said we have BCC 320, 1 and 2.
Yes.
Yes.
So for the BCC 120, it's 2 files as well?
No, it's BCC, the 2 files is BCC 321, BCC 322.
Now, just to assist you,
yes,
let's follow on the list, with respect to the list. Whichever is outstanding, you tell me there's one that is outstanding. Do you understand?
Okay. But I'm following from my recordings.
Yes, I saw you've already recorded it. So
yes,
now let's have our records tally before we apply to tender them.
Okay.
Let's start again. Do you have the first file as BCC 620?
Yes, Council.
Good. Do you have the second file as BCC 318?
Yes.
The third as BCC 520?
Yes, Council.
The fourth BCC 220?
Yes, Council.
The fifth BCC 420?
Yes, Council.
The sixth 120?
Yes, Council.
The seventh 320 in bracket 2?
Yes, Council.
The eighth 320 in bracket 1?
Yes, Council.
The ninth is BC 120. Do you have that? Or that is expunged?
120, no.
No, 218.
Yes, no, you know, he called 120 twice, but then said that in fact it's only one file. Yeah. I want him to confirm it's just one file.
Yeah, BCC 120 is only one file.
Thank you very much. Now we expunge that. The ninth would be BCC 218.
Yes, Council.
The 10th, BCC 118.
Yes, Council.
And the last will be BCC 1 of volume 1.
1?
No, 121.
1?
Of 21.
121. 121.
Yes.
So you have 11 files altogether?
Yes.
Thank you very much.
Council, can you rearrange it as per year, orderly, so that you can we will be able to admit them in a bundle?
As the commission places.
Yes. So you start with
2018.
1 of 118, then 2, then 3 of 18. Write it down sequentially.
Yes.
Please. Thank you.
We have, we apply to tender procurement files as identified by the witness. 11 files in total. The first is BCC 118. Is that correct? Accurate?
Yes.
Yes.
The second will be BCC 218. Is that accurate?
Yes.
Do we have that? The third is BCC 318. The fourth is BCC 120. Is that correct? The fifth is BCC 220. The sixth is BCC 320 in bracket 1. The seventh, BCC 320 in bracket 2. The eighth is BCC 420. The ninth, BCC 520. The 10th is BCC 620. And the 11th file is BCC 121.
Thank you.
All in evidence as an exhibit, Madam Chair. We apply to have them admitted in as a bundle, Madam Chair.
That's the court. The public procurement files from their office, from the Banjul Municipal from the Banjul City Council are hereby admitted in evidence and marked as follows. The files therein are, okay, let me take that again. The Gambia Public Procurement Authority files for Banjul City Council are admitted in evidence and marked as LGC/GPPA/BCC /1 of 8, 2 of 18, 3 of 18, 1 of 20, 2 of 20, 3 of 20 in brackets 1, 3 of 20 in brackets 2, 4 of 20, 5 of 20, 6 of 20, and 1 of 21 respectively admitted in a bundle.
As the Commission places. We also have another file from BCC. Can you please identify this file? Can you please call the identification numbers in chronological order? So which file is the first?
Okay, first we have BCC 321.
BCC 321. Second?
Second, we have BCC 421.
421.
Yes.
Third?
Third, we have BCC 122.
122. The fourth?
Fourth, BCC 222.
222. The fifth?
Fifth, BCC 322.
322. And the sixth one, if there's any?
BCC 422.
422.
Yes, sir.
Is there any outstanding?
Yes, the last one, BCC 123.
123. Madam Chairperson, Honorable Commissioners, we applied to tender 7 files from the GPPA as identified by the witness. The first is bears the number or identification details BCC 321. The second is BCC 421. The third is BCC 122. The fourth is BCC 222. The fifth is BCC 322. The sixth BCC 422. And the last one, which is the seventh, is BCC 123 in evidence as an exhibit. We respectfully apply that they be admitted as a bundle.
The GPPA, the Gambia Public Procurement files for BCC are hereby admitted in evidence and marked as LGC/GPPA/BCC /3/12, 4/21, 3 of 21. Sorry, let me take this evidence again. The Gambia Public Procurement Authority files for BCC are hereby admitted in evidence and marked as LGC/GPPA/BCC 3 of 21, 4 of 21, 1 of 22, 2 of 22, 3 of 22, 4 of 22, and 1 of 23, respectively, are admitted in a bundle in evidence.
As the Commission places. I also have other files from Mansakoko Area Council that you have submitted before the Commission or to the Commission, and also files from KMC. So we will also equally follow the same procedure, possibly ask you to sort it out and identify the files and tell us whether it is, or these are the ones that you have submitted for the purpose of its application to be tendered.
Yes, I am being told by the registrar that it is time for break. It seems we have a lot of documents to admit, and I believe that the next municipality will be KMC, and I think this is a convenient point to stop. We will go for lunch and prayer break, and we will be back at 2:30 sharp.
As the Chairperson pleases, and as the Honorable Commissioners please.
Thank you. We may rise.